Oh, yes, oh, yes, oh, yes. This honorable court of criminal appeals for the state of Tennessee is now in session for third to adjourn. God save the United States, state of Tennessee, and honorable court. Please be seated.
Good morning and welcome to the call of the July docket for the Tennessee Court of Criminal Appeals, Western Section here in Jackson, Tennessee. We're delighted you chose to be with us today. I'm extremely happy to be with you today. COVID has changed a lot of ways we do things, and a lot of drawn our attention to certain things that we may not pay much attention to from time to time. But 37 years ago, I was blessed with a son, John Everett Williams. I'm going to take a minute of personal privilege to wish my son a happy birthday. He brought me much joy. Very proud of him, and a wonderful daughter-in-law and two granddaughters, Emery and Everly. So happy birthday, son, from Daddy. He loves you. With that, my next family that I love, second to them, is with me. I'd love to introduce the panel of the court today. I'm so proud. I'm the presiding judge of the Tennessee Court of Criminal Appeals. I'm so proud of all my colleagues. When this pandemic started and we all got together, we wanted to make things accessible to everyone that we could. We wanted to commit ourselves to working a little harder and differently under the circumstances. I got to looking the other day just to see how much of an impact that COVID might have had on our product and what we were doing. Of course, I've never spoken public with a mask on, so that's new. But we filed 40 more cases this June than we did the same time last year. So we're working harder, we're working differently, and we are literally getting the cases out in timely fashions and are not behind at all. And I just want to thank my colleagues publicly for what all they're doing to stay focused. It's not easy working this way and changing the protocols of long-standing areas, but we're doing three things I think great. If you want to see us, come and be with us. Sit in the courtroom, because this is the way we've been doing it for years. You can come and be with us. Just let our clerk know and we'll make arrangements for you to be here. If you wish to watch us on YouTube live, you can watch us on YouTube. If you don't have access to a computer, we have a call-in number that you can call and listen to each and every argument that the Tennessee Court of Criminal Appeals has. And it's really a no call. It's a no charge call. It's a toll-free call if you wish to do that. With that, I do want to introduce my wonderful panel today. My left and your right, from Shelby County, Tennessee, Judge Ross Dyer, and my right and your left, also from Shelby County, Tennessee, Judge Camille McMullen. Each side is given 20 minutes. If you're the appellate and you wish to reserve time for rebuttal, please do so upon announcing or introducing yourself to the court. You may remain seated. You may leave your mask on, or you may remove them during your speaking part of the program if you wish. And I will try to help you with the time management and let you know when it's getting close to your rebuttal time. Anything else that you can think of this morning? With that, Madam Clerk, would you please call the first case?
Grooms, Hamm, Lesslie, Christian Smith, Hatley, and Jimmy.
May it please the court, Jim Gaylord on behalf of the state. If I could reserve 3 minutes for rebuttal.
Yes, sir.
This should never happen. Rule of Professional Conduct 1.11 does not contemplate or provide for the imputed disqualification of entire government agencies. And the district attorneys raise a special concern because they are constitutional officers and they are directly elected by the voters of their district. Now, That's not to say that disqualification of a district attorney is an impossibility, but the circumstances must be extraordinary. This court has held open the possibility that a violation of due process could occasion such a thing. But in order to make out a showing of a due process violation, there has to be an actual conflict of interest, and there has to be a likelihood that the defendant cannot get a fair trial. Another possibility that we have adverted to is the prospect that an impropriety could be so pervasive that reasonable members of the public would be left with a firm conviction that the judiciary simply is not functioning properly.
Counsel, as a practical matter, under what circumstances, aside from what was in Oric, and you have private parties involved, what would be a situation where a DA would be disqualified?
Due process claims are likely to be limited to dissemination of confidential information, and a separation of powers problem could arise. I think our case would be the Colbreth case, which was effectively a prosecution that was funded by a special interest group.
So those really are the only two limited circumstances under which you would say the DA's office would be disqualified.
And those are the only two that I can think of.
I know those two cases, we have two cases on point with that. I just wanted to get your initial view as a practical matter, what other circumstances would apply?
I can't think of anything easily. There might be other pervasive conflicts that could amount to a separation of powers problem other than special interest groups funding prosecutions. But that would represent such a profound breakdown of the political process because the DAs are self-regulating. They don't want appearances of impropriety because they are elected. So it's only in those rare circumstances where that process breaks down would it be appropriate for an elected judge to disqualify an elected district attorney. And those features are not present in this case.
So are you also suggesting that only actual conflicts?
Yes.
No appearance?
No, the rules.
And no possible.
I'm sorry.
No possible conflict, but must be an actual.
Must be an actual conflict, yes. And that is at least in part because the rules of professional conduct did away with the old appearance of impropriety standard. That standard was judged to be too indeterminate, too malleable to go forward, and it was abandoned when the code was effectively rewritten. And what happened in this case is that the trial judge did not find an individual conflict of interest and then articulate a ground for imputing it to the rest of the office. It found an appearance of impropriety that touched on the office as a whole. But in truth here, there's not even an individual conflict of interest. The chief claim here appears to be that if the same prosecutor both prosecutes a defendant and is also prosecuting a case in which that defendant is alleged to be a victim, that the prosecutor will fail to abide by his duties under the Victims' Bill of Rights Act. But there's two problems with that claim. The first of these is that there's no representation. This court has made plain that prosecutors do not represent the victims of crime. But in order for there to be a conflict of interest, there has to be a material limitation on a representation, not a limitation on a duty.
But wouldn't the best way to handle this situation is to let one prosecutor from the office prosecute the case and then shield them off from the other case in which the defendant is a victim and let another prosecutor handle that case?
I think I would agree that the best practice would be to have different prosecutors.
And if that mechanism was set up from the beginning of this case, let's just say, then are we even here?
Well, probably not. Part of the problem here is that in one case, it's not even evident from the record that there is in fact a victim status. And the other one, it's at least not clear from what we have that the DA intends for the same prosecutor to handle both cases. So it's a bit premature to say that different prosecutors should be appointed. And I'm not sure that we would need an ethical wall. There's no confidential information moving between.
It seems to me whether there really needs to be an ethical wall or not, it at least goes back to the appearance standard, so to speak, that, hey, this whole thing is above board because we put an ethical wall there. And that's, I mean, it seems to me that we could have handled this situation from the beginning at the trial level if the DA had just walked in and said, here's my plan, but that's not what happened.
Well, again, in the Grooms cases, we do not know, in fact, that Grooms is a crime victim. And in the other cases, I mean, the technical record in the Hatley and Swafford cases consists of an indictment and order of disqualification. I'm not certain that the DA had an opportunity to put anything in place. But I think we agree that probably the best practice is at least to have two different prosecutors. But saying that that's a best practice is not the same thing as saying there's a conflict of interest. So, yeah.
Counsel, can I ask another question as a practical matter? The trial court here seemed to be readily or reticent to ask for a pro tem DA. And speak to this if you can. If you can't, I understand. How common is the practice for pro tem DAs to be, I guess, responding to the rural areas in situations? I know that there are smaller DA offices or offices of the district attorney that cover, you know, a variety of counties. But how common is it for such a request to occur and be fulfilled by the DA's conference? Do you know?
I can't speak to rural counties in particular, but I can tell you that these requests are entirely common. I believe in 2019, there were 228 pro tem requests addressed to the DA's conference. At least 220 of those were recusals, not disqualifications.
Okay.
The fact of the matter is DAs recuse themselves all the time for things that we would not consider a conflict of interest. It's just, it doesn't look very good. It is not in the best interest of our office that this office continue the prosecution. And that goes back to what we were discussing earlier, that the DAs are self-regulated. And there has to be a profound breakdown in that regulation before a court would intervene and relieve that constitutional officer of his duties, even in a particular case. So no representation, so no conflict. The other problem with this idea that the prosecutor will not fulfill his duties under the Victims' Bill of Rights Act is it rests on supposition. It supposes that an officer of the court will not abide by the requirements of the statute merely because he's prosecuting this defendant in another case. Stated another way, there's no reasonable likelihood that this duty owed to a third party is likely to be materially limited. And it's important to keep in mind what that duty is, and it's simply a duty to confer. This is what's going on in this case. We've received a settlement offer. Here's what we plan to do. Because it's simply a duty to confer, there is very little reason to think that the prosecutor, for some reason, is not going to do a rather small duty of that nature merely because this victim is a defendant in the case. So no conflict of interest on that ground. The secondary claim that has been raised here is, well, maybe the victim would be called as a witness to testify to the theft in this case. But that's not a conflict of interest either, because that sort of thing happens all the time, in fact. I mean, we have co-defendant turn state's evidence in hopes of getting some favorable consideration, but there's no deal ex ante with the DA's office. And so the prosecution continues. Well, no one thinks that that prosecutor is disqualified. What we think is that maybe the witness has an incentive to testify favorably, but that's something that can be brought out on cross-examination. It's not a disability on the part of the attorney. So there is quite literally nothing to impute in this case. There is no conflict of interest. But even if there were, I don't see why the procedure that Judge Dyer has proposed would be perfectly adequate to address the matter. So we have Prosecutor A handling the defendant case, Prosecutor B from the same office handling the victim case. Where is the constitutional problem such that the constitutional officer should be relieved?
Do you think, should we agree with you that we should spell out that directive in our opinion?
I think it would be permissible to say, I mean, it would be fine to say that that is a best practice. We are asking you not to hold that there's a conflict of interest there, because I don't think that there's a foundation for a finding of conflict. And the DA in this case may well be willing to appoint separate prosecutors, say in the Hatley and Swafford cases. Time will tell. But in the circumstance where we've got prosecutor A, prosecutor B, again, where is the problem is I don't think anyone has mounted a serious explanation in this case why defendant Grooms cannot defend his murder case if a different prosecutor handles the theft cases in which he is alleged to be a victim. And likewise, it's very difficult to imagine that reasonable members of the public being possessed of these facts will think that the judicial system just isn't doing its job. So consequently, there's no basis for imputation, even if there were a conflict of interest, but there is not. So the trial judge abused his discretion in this case, but he did more than that. These disqualification orders are in fact unconstitutional because they deprive the voters of the 24th Judicial District of the services of their elected representative. And so we would ask that the orders be reversed. Thank you.
You have your full 3 minutes. Mr. Hesse?
Yes, sir. Good morning. My name is Paul Hessing. I'm Assistant Public Defender of the 24th Judicial District, primarily assigned to Benton County. We pretty much handle all cases that go through that county, where there's a juvenile general session circuit and do a vertical defense. I represent Derek Grooms in the Grooms, Lesslie, Hamm, Smith series of cases, and I represent Benny Swafford Jr. in the Swafford Hatley line. And as the question is presented to the court, whether an entire district attorney general's office may be disqualified because of the defendant in one case is a victim in another, there should not be a per se rule. To do so would be to ignore the real and substantial differences in the compositions of each judicial district and other factors that contribute to an office-wide conflict. Larger counties and districts such as Davidson County or maybe Shelby County, there are many, many more attorneys in those offices, many more sections of prosecution, where it would be easy to isolate people off, attorneys off when a conflict arises.
But isn't that whether it's a big county or a small county, isn't that the elected district attorney's responsibility to make that determination how they can ethically wall off their people and use their people? And it's not the trial court's job to just flat out disqualify an entire office without at least providing the opportunity to show how that office can handle what you allege is a conflict?
Yes, Your Honor, but I think that goes back to the totality of the circumstances. If that court, and the trial court's in the best position to know this and understand this, if the trial court has issued orders in the past for a district attorney, elected official to form a firewall or have certain prosecutors, or maybe even the district attorney himself, not be involved in a case, and then later on it comes out into the judge's attention during hearings that did not happen, and the trial court has prior knowledge that this office, this particular office, or this particular district attorney has not done so in the past.
Okay, counsel. I don't know, there was some reference or the trial court here did allude to some past failures of this DA's office, but we have no idea what that is, okay? I want you to focus on what the trial court did in this particular case. He disqualified the DA's office, the entire DA's office, based on an actual conflict of interest.
Yes, Your Honor.
Which is what?
Which is what, well, Your Honor, the record is void of that because
That's a problem that I have with this record.
We never got to have a hearing.
I thought you did have a hearing.
We had one witness that testified as a TBI agent, Joe Walker, former TBI agent, Joe Walker, testified as to one issue. The court continued the case, stopped the hearing, continued the case to April, from whatever date that was, to April 23rd. And we were going to have additional proof at that point in time. The parties arrived on April 23rd. There was no additional proof that the court allowed. The court issued its ruling at that point in time.
Well, then if the record doesn't show a conflict, how can we rule otherwise than he abused his discretion?
Well, what I'm asking this panel, this court to do is to remand these cases back to the trial court so that Mr. Swafford and Mr. Grooms can have their due process. Let's get that information into the record And then this court, the trial judge, and anyone else can see whether there is or there is not a conflict. So the state's saying, we don't know that Mr. Grooms is a victim. Well, we've never had that opportunity to even get those issues before the court. So-
Okay, well, I'm a little confused because this is the state's appeal
Yes.
of the trial court's disqualification of the DA's office.
Yes.
So number one, the question that you have not answered for me is whether a defendant's status as a victim in another case serves as proof or evidence of an actual conflict of interest, which is the order that the trial court found that in this case. And that to me, I'm trying to get an understanding from you on that issue. You're speaking to other defendants who have submitted their briefs and said that this issue really is not dispositive of their case. They have no real claim here. So I'm talking about the Grooms order of disqualification and what the trial court said in that case.
Well, I think the trial court was premature in its ruling.
Okay, so even in terms of Grooms, you think the trial court was premature in saying that the defendant's status as both a defendant and a victim is proof of an actual conflict?
I think it's not as simple. There are more factors that have to be considered than whether or not he is just simply a victim. I think there are cases where you can be a victim and a defendant at the same time, and it's not a conflict.
And you're asking to provide, or for us to remand for more proof on the issue?
We never had the opportunity to present the proof
And why is that?
because the court made a ruling and precluded us.
So you didn't ask to put anything on a record or make an offer of proof? You just accepted that you won and sat down?
We were not allowed to, I can read to the court from the volume 10 of what the court said on the first hearing that we had. It was, I'm going to recess this hearing and come back on the 23rd and continue. I don't want to shortchange you. I want to be able to develop anything you want to develop at that time. And I particularly want to hear, then he paused, am I to understand he's the victim in another case that they're prosecuting? And that's the answer to that was yes. Then we came back on April 23rd with the intentions of putting on more proof, but before any witnesses could be called, the court made a ruling.
Okay, well, what other proof? Let's say we did do what you asked. What other proof?
Well, in this particular case, Mr. Grooms, the assistant district attorney who handled the case from its inception, through general sessions, preliminary hearing, to grand jury, to these motions, is going to be a fact witness. She's going to be called as a witness. She was on the crime scene.
That was developed at the first hearing. And the trial
Partially.
court didn't buy that. The trial
Partially.
court, and it actually happens a lot. That's not proof of a conflict of interest.
There was one witness who, Joe Walker, was not in the same room as to what this assistant district attorney did in another room with a different TBI agent. What she saw, what she heard.
Okay.
We don't know that. And perhaps if there were a hearing, it would come out that she's not necessarily a fact witness. But at this point in time, only information that Mr. Grooms has, he obtained through discovery, learning for the first time that when the assistant prosecutor shows up in crime scene photographs while the crime scene is being prosecuted and later finds that she was participating in the collection of evidence, and through the testimony of Joe Walker, who he breached protocol, TBI protocol, by allowing her into the crime scene.
And that was developed in the record.
That was developed in the record. That's where we stopped. We could not proceed forward. While Mr. Grooms is not listed as a victim in the other warrant, there are witnesses who can testify to that. We were never allowed to get there. Chief Deputy Jason Lowry can testify as to why his name is not on there.
Well, they don't, if somebody's house is burglarized and they're not the owner of the house, but they stay there, they don't have to list them as a victim, do they?
Well, it was a theft as well, Your Honor, and
Well, they don't have to prosecute that theft, do
they don't have to, but therefore, that is the issue. That's the evidence of the conflict. That's the fruit of the conflict.
So
If they choose not to prosecute that, that is evidence that they are not treating everyone equally. If they're doing that because he is a defendant, if they do that because they have a connection to the family, because the decedent's mother owned the house. So she is technically the victim of the burglary. His items, their items, the marital items, were in the house. They are located also in crime scene photos that I received in discovery in the homicide case. It's the same items that were listed.
So are you wanting us to write or want the law in the state of Tennessee to be that if I am a district attorney general and I'm prosecuting you for DUI and your house is burglarized and, you know, let's say somebody is kidnapped, or one of your family members is kidnapped or something, that I can't prosecute that crime as well?
I don't think that should be the law. No, sir.
So-
I think it's a very fact-specific, case-specific.
Well, what's the fact in this case that will distinguish what I just said? If it's not just a red letter or black letter law, that if this happens, you can't do this.
You have to look at the case specifically. You have to look at the individual office's actions or the particular prosecutor's actions in regard to that particular case. Are they acting with disregard of this person because they are a defendant? What's motivating their actions? Are they being impartial? If they're being impartial, there's nothing wrong with prosecuting somebody. But if you're treating someone differently,
Well, short of the DA coming out at the hearing and saying, I'm not prosecuting this crime because he's a defendant in another case and he's the victim in this case. I mean, they have discretion in how they prosecute and what they prosecute. And so short of this prosecutor coming out and saying, this is why I'm doing this, is to treat him differently because he's a defendant, how are you ever going to prove that?
the issue in this particular case is this: it's the same district attorney, assistant district attorney, who's handled all these cases from their inception. Okay, so she's handled all these cases. She is going to be the one who puts one victim on the stand. And in this particular case, Mr. Grooms possibly has given some contradicting statements as far as his actions that night. She's aware of those. They're in the record. But on the next turn, and she said as much in court, she's going to put him on the stand. The only thing she's going to ask him is this your stuff? Did you give my permission to take it? And what's the value? So in one sense, she's going to present Mr. Grooms as an honest person telling the truth.
Now, I just want to make sure I'm clear. The two cases are not related. The only connection, the two cases are not related, correct? There's no.
I'm sorry, go ahead.
I just want to make sure factually I'm correct in understanding. These two cases factually, the homicide occurred first, correct?
Correct.
And the theft occurred sometime later, well after.
Correct.
And there's no allegation here that they're in any way connected, correct?
They're not connected. Well, they're not connected per
Other
se.
than his status as the victim or the alleged victim in the theft.
Other than the night of the homicide that occurred, his statements that he gave, and then his statements he gave later, was that he was under the belief that someone was breaking into his residence. And there's a history of he and his wife hearing people outside possibly trying to break into the residence. That's his version.
Okay, so it leads me back to Judge Williams' point, and I'm trying to understand, unless you're just pointing to specific facts, you're asking this court not to really carve out a specific rule. You're just saying that ethically, this DA should be somehow, she should recuse herself somehow because she might have special knowledge based on her involvement in the theft to prosecute the homicide? Is that what you're trying to say?
It's a totality of the circumstances.
There is no totality of the circumstances. I don't know where you're getting that standard.
Well, you're asking me if I want the court to draw a line or draw a rule.
That's why you started your argument. you said you didn't want us to craft a per se rule in these situations.
Not a per se rule. It has to be dependent upon the fact, how large is this DA's office? How many people in this DA's office have a conflict?
And we don't know.
We don't know.
Because you didn't put on any proof and didn't ask to. You just took the win and left. Right?
Yes, sir.
Okay.
I mean,
So whose obligation was it to bring us a record that we could make a decision?
I suppose Mr. Grooms, Your Honor.
Okay.
Um,
So in that regard, if she's just, you know, it's not in the record whether the district attorney general has ever talked to Mr. Grooms. Is that correct?
It's not in the record whether.
Yes, sir.
It is not in the record. It is in arguments and statements, but it is not as far as proof was provided.
So we have no proof that she has ever talked to Mr. Grooms at all.
That's correct.
And we
But
don't know that she will be the one that will prosecute Mr. We don't have any evidence that she will be the one that tries the burglary case.
Well, to this point, she's handled everything, and I've been notified of no one else who is going to. And I think Judge Dyer is right. If things in the beginning would have been very simple, we would not even be here if the DA's office would have not lumped every case into this one assistant district attorney and said, run with it. And if it would have been found out in the beginning, earlier, even in the preliminary hearing stage, and matters would have been divvied out.
Well, it's not even in the record that Mr. Grooms testified at the preliminary hearing, is it?
He didn't testify at the preliminary hearing.
So he's never talked to the district attorney general, never been used as a witness. You say he may be used as a witness. He's not needed to get the convictions for burglary. Might help it, but it's not needed. I'm just really struggling to find an actual conflict without setting out a rule that says if you're charged here and you're a victim here, the DEA's office, entire office are out.
I just think it's very difficult. I mean, obviously, Mr. Grooms would like you to establish such a rule, but I think.
Well, you said no.
Well, I don't think that's.
You asked me specifically not to set that rule. You asked me that it needs to be fact specific. And I asked you, what fact do I need to be looking at? In this case, that has been proven on the record that there is an actual conflict.
And my answer to you is that because there was nothing put into the record after the court stopped the hearing and made and issued a ruling, there's not a fact that we.
So you agree that the trial court erred in disqualifying the entire DA's office?
I think it was premature. And I think it was premature. Doesn't mean that there's not an actual, because if this court makes a ruling that there's no conflict and there is an actual conflict later and it comes out at trial, where does that leave Mr. Grooms? I mean, just saying that there's no conflict doesn't make it so. Or there's not a conflict in the record doesn't make it so.
I agree with that. I can certainly see where something can arise during a trial, but I think you got a brand new day then. You need to be as much as an advocate for Mr. Grooms then as you are today, and you're doing very well with what limited stuff you have. But you know, if the district attorney general start testifying and they start telling you what's going on, then yes, I think you ought to be raising these questions again. And I think the trial judge is free to look at the issue again. But
you know, and I'm here simply because the state filed a Rule 10 motion. And originally I asked the judge to, you know, recuse the assistant district attorney. That's where I started, that specific district attorney. And then things progressed from there. And then the next thing, the entire office is disqualified without, you know, there's, Hadn't even got into this, a guardian ad litem who was in private practice at the time for the child
Well,
is now in the
that's
DA's
not
office.
before us. That issue is not.
It's not,
before
no,
us.
it's not.
And
because
the
it
other
didn't
issue is not before us. And then if you really and truly will be satisfied with somebody sending it back and saying, the same prosecutor shouldn't be prosecuting both cases, as the state has suggested that we just put in as a best practice, this shouldn't happen. If that happens, your problems are solved, correct?
For the most part, yes, Your Honor.
Okay. You may win after all. Mr. Hesse.
I just want a trial for my clients, Your Honor, that's fair and, you know, that everyone can agree that substantial justice has been done.
I hope you know we appreciate that, but writing a law that affects the entire state of Tennessee on one rule, that if this happens, this happens. We've got to be very, very careful about the facts and circumstances we have and the record we have before us to make such a broad rule.
I do understand that, Your Honor, and I agree that this question is a very, very narrow question. And I know it's not before the court, but that question does not encompass this case, or does not totally surround this case. I mean, this case is more than that, but I know before the court, what's before you today is a very limited issue, and I agree with that. Thank you.
Thank you, Mr. Hesse. State have anything further?
Very briefly, it sounds like we're agreed that this needs to go back. What I would like to call attention to, I think, is Judge McMullen's comment that regardless of whether he can reopen the proof and prove that Grooms is in fact a victim or prove something about the functioning of the district attorney's office, even if you take what he is saying is true, it's not a conflict. And even if it were a conflict, there simply is no reason why the procedure proposed by Judge Dyer wouldn't be perfectly adequate to solve it. There is no basis whatsoever for the disqualification of an entire DA's office in this circumstance. And I think the court should say that, because if it's not said and it simply goes back for inadequate facts, we could well be back here in 6 months talking about the same issues. Thank you very much.
Thank you both. Anything, Judge McMullen? I'm good. Thank you both for very well presented arguments this morning, and we'll stand adjourned to call the next case.
All right.